सुप्रभात साथियों, जैसा कि मैं आपको बता दूं कि आज हमारे फैकल्टी ऑफ लॉ में यूनिवर्सिटी ऑफ लखनऊ का जो फैकल्टी ऑफ लॉ है वहाँ पे आज इस समय मैं अपने सेमिनार हॉल में उपस्थित हूँ और आज यहाँ पे बहुत अच्छा सेमिनार होने वाला है जो कि BNS और BNSS जो हमारा नया क्रिमिनल लॉ बना हुआ है उसमें आज गहन चर्चा की जाएगी। मतलब यहाँ पे उपस्थित होंगे BHU के किंग वर्ड्स प्रोफेसर डॉक्टर मुरली सर, और अगर हम बात करें हाई कोर्ट इलाहाबाद के जो लखनऊ में बेंच है उनके जज श्री या मिस्टर राजीव सर, तो बहुत सारे प्रोफेसर यूनिवर्सिटी ऑफ लखनऊ के फैकल्टी ऑफ लॉ के उपस्थित रहेंगे और अपने अपने शब्दों के द्वारा हमको ये बताने का वो प्रयास करेंगे, अपने वक्तव्य को रखेंगे कि हाँ पहले के जो क्रिमिनल लॉ थे आज के जो क्रिमिनल लॉ है उसमें क्या बदलाव किए गए हैं। तो वीडियो को पूरा देखिएगा।
The person was pretending, having some pretext, that he is of course having a problem, he is admitting himself in the hospital, and that is precisely the reason the Supreme Court said that you can take him into police custody even after 15 days. The same thing is reflected in the new law. Today the new law permits the police to take him into police custody even after 15 days, but before 60th day, when the maximum period of remand is 90 days and 40 days when the maximum period of remand is 60 days. This is my interpretation. So again I am just telling you that today according to me the maximum period of remand is 15 days only. The only change is what? Today there can be police custody even after 15 days. Now you see my dear participants, you will ask me, see why we are not permitting police custody after 15 days. Let us take a fundamental question. See, first 15 days only the earlier law permitted police custody. Why? Because as the investigation goes forward, police become more notorious. So the law did not want them to give them police custody after sometime in the investigation. So they permitted police custody only in the first 15 days. Which today can go even beyond 15 days, but before 60th day. So I will take only 15 minutes time because I think I have to cover a large, bigger area. But then I will be very fast. And then now you see, when we come to 170, very important change has been brought about. What is the 170? When the police, of course, submit a police charge sheet. Suppose the accused is not in custody, because the accused must also be forwarded to the magistrate. But in the 170, that means the new BNSS, 170 has become some number, I don't know exactly the number. But it is written that if the accused is not in custody, the police can take a bond from him, bond from the accused, and produce that bond before the magistrate and tell the magistrate that the accused is on bail and we have taken a bond from him that he will appear before the court. Earlier, this language was not there in the 170 CRPC. Now let me come to certain very important changes. Let me bullet points because my time is limited. Now, public servants, very important change has been brought about. When I was a student, my dear participants, I was reading newspaper Hindu very regularly, particularly editorial column, wherein the politico-bureaucratic nexus. That means the IAS officers, IPS officers, they take bribe, or the arrested have taken bribe. And you cannot take cognizance against them without permission from the government. And government was not giving permission. So these people were not prosecuted. So cognizance is not taken. The time was, government was not giving, or if the government gives permission, it was giving after 2 years. Supreme Court said that. Now if the government does not give permission within 120 days, that means particular public servant is there, allegations are made against him, magistrate wants to take cognizance and permission is awaiting from the government. Government did not give permission for 120 days, the government is silent. Now the Supreme Court said after 120 days you can deem that the permission has been granted. Why? Because that is the only way to prosecute him. That is the politico-bureaucratic nexus, which of course is responsible for, sorry if I'm a small man using big words, I'm extremely, because High Court judge is also with us. I am not that competent to use, but then this made me feel when I was a student. Now the black money in the country, if I am not to be misunderstood, that is also responsible. The reason is because of these sections. Because the government is not giving permission. So cognizance is not being taken. But salute to the Supreme Court. Supreme Court said that 120 days, if the government is silent on that particular matter, now after 120 days you can deem that the permission has been granted and the magistrate can go ahead and take cognizance. Now the same thing is reflected in the BNSS. Now what is reflected in the BS 120 days, it has come into the statute now. But that is because of the Supreme Court judgment. Now let me come to, see, let me tell you a very important change. Now these are all very important changes. Now a very important change is that the earlier 190 CRPC. Now what is that 190 CRPC? You all know it's a very fundamental section where the case is instituted for the first time. That means in CRPC 190 is important because whether it's an offence of rape or murder. Now that case is always instituted in the 190 court. That court will take cognizance and trial is a different matter. Taking cognizance is one matter, conducting trial or inquiry is another matter. Now, in the 190 CRPC, what is the first word? Complaint. Today a change has been brought about. What is the change you know? Now complaint given by any officer under a special law. That means today we have the Money Laundering Act. We have many important economic legislations to check black money. Now, any complaint made by an officer under the special law, that is also included in the section 190. Today the new section is 210. 190 has become 210. Those of you who have the Bail Act, please look into that. It is written in 210 very clearly. Immediately after the word complaint, it is written that any complaint given by a public an officer under the special law. I have a big complaint on this. I have a big objection. What is that objection? Objection is that now, why are you bringing a complaint made by an officer under a special law into the definition of a complaint? He is an officer like a police officer. For example, Money Laundering Act. Those officers under the Money Laundering Act, they have enormous powers. So when they submit a report, let us not call it as a complaint. And to avoid public scrutiny. Complaint means it avoids public scrutiny generally. Police report means it comes under public scrutiny. So here, my dear participants, I don't understand why the legislature has made the complaint under the special law given by an officer. Why it is saying it is a complaint as though it is a private complaint? Because complaint means private complaint. And second material is police report. So I want this complaint, this particular report made by officers under special law to be put in the category of police report and to expose it to public scrutiny instead of hiding it from public scrutiny by saying that it's only a complaint. Okay then, okay, my time has come, I'm leaving. But then I would request the organizers just to give me 5 to 7 minutes time. That's all. I will be very faithful to my word and then I will complete. Now you see, that is of course a very important change. And when we come to 223, that is of course I already told you, any public servant can be proceeded against only when you receive a report from the superior public servant, and that public servant is of course given an opportunity to assert himself. And because persons are waiting for behind me very anxiously, they are waiting when I will leave. Generally I am called as a my caster.